Good morning, everyone. I must say I'm very pleased to be here today to participate in this symposium. I'm enormously interested in the ideas, the questions that are being pursued here. And I'm enormously interested in the idea of enhancing the conversation between law and medicine and other disciplines working with children. So I come at this question from the perspective of the justice system and from the question of its capacity to effectively manage issues involving vulnerable children. The justice system is a very complex, very demanding environment. It deals with large numbers of children and their families, and it exercises considerable authority. I think that the quality of the experience that children and their families have in the system, the quality and effectiveness of the outcomes can have lifelong impacts, long-term consequences for children. So it's from this particular perspective that I want to talk about two general points. The first is there's much going on in law today. Many of the traditional approaches are being questioned. Many of the ancient verities are no longer universally accepted. We're recognizing that the quality of experience that children and families, well, everybody in fact, but in particular children and families are having within the justice system is poor. And at times the experience vulnerable people have inside the justice system is very poor. So I want to talk about that. It's been a shock, I think I can say, to the system. We've had research that has demonstrated this to us, and it's provoking self-examination and driving fundamental change to legal processes, to legal roles, and even, I think, to legal culture. So I think it might be useful for me to explain a little bit of that background. And then I would like to describe the change itself, to tell you what that looks like and see what some of the implications might be for people who work with lawyers and judges and work in the system. Warning, I think I have a little too much material, so I may be moving fairly quickly through these slides. So when I talk about poor quality outcomes or poor quality of experience, I'm essentially talking about two things. The first is that the justice system is largely inaccessible, and it's inaccessible in a couple of different ways. It's inaccessible financially. The cost of legal representation is beyond the reach of the middle class now. It's generally accepted. This is very consequential for children whose parents are undergoing divorce or separation, because their parents can have a very difficult time trying to deal with the legal system. But even in environments where legal aid is available, as in child protection, where parents have counsel, the inaccessibility of the system takes the form of its massive complexity, the incomprehensible procedures, the intimidating environment, the overwhelming environment. And we know that parents generally often don't even really know what's happening to them in that environment, except that they find it very, very uncomfortable. So the bottom line is that in that respect is that the system is not very user-friendly to the adults. And in any event, children rarely have counsel. They rarely have direct access into the courts, and it's often left to others to assert their interests, and we know that that's not always done terribly well. The second general area of concern in terms of what people experience is we're recognizing that our traditional method for managing conflict is not very effective, especially for matters involving children and families. And I'll say a little bit more about this because I think it's extremely important. The problem with our traditional adversarial litigation, the problems it's having, it's a very large topic, but in a nutshell, there's two deficits. The first is that the system tends to frame up questions of a child's welfare as a contest or a fight, and it positions the parties as opponents or adversaries who are locked in a win-lose battle. One must win, one must lose. And when that happens, the opportunity for real dialogue diminishes as the combat values and attitudes start to take hold. The second problem comes when we take the very complex, multifaceted, nuanced problems that children and their families face, and we try and translate those into legal issues. And in a way, the effort to try and translate these questions into legal issues is often, in one respect, a little simplistic. And usually the question translates into some form of who gets the child, which is the wrong question to be asking. We have, in the process of framing the legal issue, typically eliminated a lot of information that really should be part of the discussion. So the good news is that the system is increasingly recognizing the costs and the deficits that come with this approach. Procedurally, we understand the system is too complicated, it's too expensive, it's too slow. The speed is an enormous issue for matters involving children. As I'm sure everybody in this room understands, children are developing all the while that adults are disputing over their welfare, and it's just unacceptable how long it takes to resolve some of these disputes. The impact of this process on relationships is one of the most troubling dimensions of it. The adversarial approach amplifies, it exacerbates conflict, it polarizes the parties, it closes down communication, and it's very stressful for people who participate in it. And this all impacts the outcomes, the ultimate outcomes. Very significantly for the child protection context, the adversarial process tends to undermine working relationships. So that vitally important long-term relationship between social workers and families tends to be undermined by the experience of the court process. Further, because we haven't tended in the legal system to address the whole complex question in its context, our solutions don't tend to be very sophisticated, and they're certainly not durable. And so we see parties coming back over and over and over again into the system. And on top of that, people, we've learned, are less likely to accept outcomes, dispositions that are imposed on them. And that's absolutely what happens in the justice system. So all of this has now been very well documented in a mountain of reports within the justice system. And the conclusion basically is that the model's not working well. It's not working well for lawyers. It's not working well for people who come to lawyers, and it's certainly not working well for society. So we have reports recently that are making some very strong statements, and I put just 2 bullets up at the bottom of this screen, but statements like the current system is unsustainable, and we cannot shy away from the dramatic level of change that's required. So I emphasize this. These comments are not atypical, and they very much reflect a tone that's developing inside the legal system at this point in time. So this is leading to change on a number of fronts, and I'll discuss 2. First of all, our thinking about what access to justice means. Historically, what access to justice has meant is access to legal representation. Can we get this person a lawyer, and can we get this person before a judge? And if we did, we thought, well, this person has access to justice. The notion now that's displaced this, I think, is much more complicated, and it recognizes that access to justice is much more than access to legal information and access to legal representation, legal advice. In fact, the emphasis has gone from the access to the justice. And we're sitting back as a system and we're saying, well, what does justice actually really mean? And what does it mean in instances of structural injustice, where we know there's intergenerational trauma that's influencing some of the problems that are coming into the legal system? And can we really deal with that in a courtroom? Is that kind of access sufficient? And the answer is that it typically isn't. And that we have to start thinking of access to justice in terms of getting people access to resources that are sufficient to address some of the underlying issues and underlying problems that are actually generating the problems that bring these people into court in the first place. The second major aspect of the change is a rethinking of our dispute resolution processes. And this involves a shift away from the combative adversarial processes to a non-adversarial problem-solving approach. And the central notion here is we've begun to recognize that people don't come to the court system because they want to litigate a problem. They come to the court system because they want to solve a problem. So there's a new paradigm evolving, and it's well articulated and implemented in a number of fronts now. It goes by different names. I prefer the name problem-solving approach. And this approach sees dispute as a problem to be solved, not a contest. It frames parties as joint problem solvers, as collaborators, not as opponents. It supports collaborative dialogue, not debate. It works with needs and interests more than with rights. And it seeks outcomes that can accommodate as many common interests as possible. One of the better examples of this new paradigm is in the area of child protection. In British Columbia, starting in about the early 1990s, we began to explore these questions in the context of child welfare and ask ourselves the question, is there a better way to do this? Can we take this out of the court system somehow? And the question that we framed for ourselves was focused around the social worker-family relationship, and how can the social worker bring their considerable authority to bear to protect a child effectively without destroying the possibility of a collaborative, cooperative working relationship with the family. And the answer we came to was that we had to somehow reframe the problem from an investigation or an authoritarian intervention into a collaborative negotiation. And this is a complex task. It involves, at base, de-emphasizing the tone of blame, moving away from the goal of trying to establish fault to improve blame, and building upon our common interest in the child's welfare. Now, we undertook an elaborate and complex scheme. I could talk for a long time about this, but in order to implement this, we moved on a number of levels. We wrote it into our legislation back in 1996. We created statutory recognition for non-adversarial processes. We encouraged people to participate at an early point in time. We didn't make it mandatory for families, but we encouraged people to participate in it. We created a confidentiality. We tried to write the statute generally so that it made it easier for people to go to mediation. We eventually created a policy framework to support that. For social workers within the ministry, the current policy, and it's been in place for some time, is that there's a presumption in favor of collaborative planning and dispute resolution. So this is, in a sense, makes court alternate dispute resolution. And the default option, the primary option to be pursued in trying to resolve an issue. Am I that far along already? Oh, goodness. Like I said, so what we've done, I'm going to move very quickly here. What we've done is, with this, we've displaced the court from the center of the drama. And we've basically made it so the court has to make room for other disciplines, for other processes, for other approaches in this area. We've changed dispute resolution processes. We now employ mediation and 3 or 4 other kinds of dispute resolution, collaborative dispute resolution processes for families. And most importantly, we've revisioned professional roles, especially for lawyers. And for lawyers, this has involved the acquisition of new information, new knowledge. We expect lawyers now to understand about child development, about mental and emotional disorders, about the dynamics of domestic violence, all of these sorts of things, treatment modalities. We've tried to legitimize the notion of an ethic of care in law. And we've tried to revise the sense of what is advocacy, not zealous advocacy for one's client's rights, but zealous advocacy for the client's and the child's needs. And this also means a new relationship with other professionals. We see lawyers being much more engaged with other helping professionals, health professionals who are working with the family. As I mentioned, this has taken a number of forms. Mediation kind of led the way, but now we have family group conference, traditional decision-making. Our First Nations have embraced this approach. It's been a huge success story on that front, very effective there, and family development response. The Ministry for Child and Family Development made the implementation of these processes one of its goals for a number of years, until basically they achieved the goal. And what you see before you are the numbers from their annual report, rising from the use of these processes in 10-11 at about 5,500, and up to 2012-2013, where they substantially exceeded their target, and we now have about 12,500 of these processes occurring every year. I expect the numbers higher. There's a question about how deeply this is penetrated into the culture. There's a real question of culture here, because what I'm talking about fundamentally is a culture change. It's a large topic, and I can say that there's been progress on that front, but I can't say that we've arrived. So, in concluding, I need to be clear. I'm not creating any simple dichotomies. I'm not saying that rights-based adversarial litigation is bad and collaborative approaches with children and families are good. It's nowhere near that simple. There are occasions where we absolutely need adversarial process. It's just not one size fits all. It doesn't, we don't need it for the vast majority of issues, for that matter. Second point I would make, I think is very important, I just alluded to, and that is this is about culture change. It's slow, but in my view, inevitable. This approach sells itself. The experience of doing this kind of work has had a large impact on social workers and on their culture. And finally, for non-legal professionals, it goes to the question of, I think it's useful for non-legal professionals who work with the justice system to be aware of these tensions inside the system, and to be aware that these kinds of approaches are available, and that you in any place in Canada now, you should be able to find people who are sensitive to the kinds of values that I'm describing, and skillful at the kinds of approaches that I'm describing as well. And from that perspective, I would urge you, because you can play a role in helping to implement these processes, to insist upon them when you have the opportunity to do so. I'll conclude there.